Justice Jackson?
So I guess I'm trying to figure out the difference between your argument in saying that you want to preserve tester standing, the testers you understand are okay, and Ms. Laufer is not. And I know that you say that she is a self-appointed tester. Is that because you're trying to distinguish her from the testers that you think have standing and don't? And what's the difference?
No, I
okay.
I'm not, that's not, I mean, she is self-appointed in the sense that she doesn't work for the government. That's all I meant by that.
I see.
But other testers who themselves are self-appointed would have standing. It depends on the particular facts.
I guess I'm trying to ferret out whether what's really hard here is drawing the distinction between a tester who actually experiences discrimination even if they don't really want the service subjectively, right? So this is Justice Sotomayor talked about the people going to lunch counters. They aren't hungry. They're not actually there for the sandwich. They're going in because they're putting themselves into a discriminatory situation in order to be able to challenge the policy. Ms. Laufer says, I'm challenging the policy. But I guess the question is she really experiencing discrimination? Is that what we're supposed to be kind of thinking about?
Yeah, so first of all, I just want to put on the table, we definitely think the person at the lunch counter has standing.
Okay. And that's because it doesn't matter that his motivation is I didn't want the sandwich, right?
That's right. That's the facts of the Havens Realty case, essentially, which we haven't asked the court to
So it doesn't matter that she's doing this to sue. I mean, I know you keep talking about her motivation. She wants to do this to sue. In the same way as it doesn't matter that the person's subjective motivation is to set up circumstances by which they can challenge the discriminatory lunch counter, it doesn't matter that her subjective motivation is to sue. There must be something about whether she's actually experiencing discrimination. That is the difference in your argument, right?
I think that's right. I don't think that subjective intent matters when there has been a concrete Article III harm, such as in the Cruz case being banned from speaking, such as in the Tester case not entering a business. And I do think that being the victim of intentional racial discrimination, as in the facts of the Havens Realty case, or the hypotheticals Your Honor has described, may inflict, in certain circumstances, an Article III stigmatic injury. We just don't think that these facts are comparable to those.
That she has actually been the victim of an injury, and that's because you say she disclaimed her interest in going to Maine.
So I think there's several differences between this case and the lunch counter hypothetical. So first of all, I think this is more of a generalized grievance, like in the lunch counter or Ms. Coleman and Havens Realty, like the person was personally the victim of racial discrimination. I think that when you just go to a website to check ADA compliance, that's more of a generalized grievance. There's also no intent to discriminate in this case. I do realize that the ADA considers the disparate effect of facially neutral policies to be discriminatory, just as disparate treatment is discriminatory. But in this case, there's no disparate effect either because she's not using the information. So there's the disrespect of intentional discrimination.
But that's all in the merits. I'm talking about injury, right? I mean, that's whether or not she could actually win the case. You're saying she can't even bring it.
Yes.
And I'm trying to understand why you think she's not injured. And I think I get it. I just wanted to be clear on the difference between her and a tester.
I mean, on the question Your Honor described about being subject to discrimination, I do think this case is properly understood as discrimination against people who are limited from accessing the building. Like, the purpose of accessibility information on a website is to facilitate accessibility of the building, and so not.
No, isn't it? I'm sorry. Isn't it to facilitate their assessment of whether or not this building offers services that they can use? So what she's the reason why there's discrimination is because an able-bodied person can get on the website and it shows that there are 15 rooms available at this hotel, and so they know that there are 15 rooms available and they could go there. Whereas a disabled person, unless the hotel identifies that it actually has accessible rooms, can't look on the website and assess the availability of those rooms. I thought that was the discriminatory issue.
Yeah, but the problem is that looking at the website is not an end in itself. I think it's a means to the end of accessing the hotel. Like, the reason you want to know whether there's a wheelchair ramp is to know, if you show up at the hotel, whether you can enter it.
Maybe. I mean, there could be a lot of reasons, right? I mean, the point is you're being discriminated against because you don't have the same access to information about the status of the hotel and whether rooms are available.
I guess I just don't view, I mean, there's no argument that respondent couldn't use the website, unlike in the hypothetical with the visually impaired plaintiff that Justice Kagan asked about. I think that her ability to use the website was not constrained. She just didn't get information that she needed to know whether she could access the building, which I just don't think is an injury unless they're going to use that information somehow.
Thank you.
Thank you, counsel.